Welcome and thank you for standing by. At this time, your lines have been placed on listen only until we open for questions and answers. You may press star 1 at any time on your telephone keypad to ask a question throughout the presentation. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn today's conference over to Ms. Janice Wingo with the International Trade Administration. Please go ahead.
Good morning, and welcome to this morning's webinar presentation on trademarks. Today we're very lucky to have an attorney in China who will be speaking to us on the freezing of the Castell mark in China and the types of remedies that the courts are providing. I'd like to introduce today's presenter. His name is Mr. He Jing. He Jing is a very distinguished attorney who's had a long practice in trademark, both on the registration side and the enforcement side. He has his undergraduate degree from Peking University in physics. Then he came to the United States where he got his Juris Doctorate degree from Notre Dame. He practiced in the United States, in California, before going to a very large international firm in Hong Kong where he continued his trademark practice. He Jing is now a partner with ZY Partners in Beijing, and he said that he would be happy to receive questions from the audience during the presentation. And if anybody is listening to the audio recording, you can email He Jing with questions as well.
Okay, great. Thank you, Janice, for the introduction. Good morning, everybody, and thank you all for taking the time to come to this webinar. And today, I would like to introduce a story about a very recent case in China, which relates to a French wine market, Castell. This is a litigation where the French company sits as a defendant in the Chinese court. And it was something which is quite unusual happened to this French company. So that's why I really picked this up and want to use this case to illustrate what could happen in China and use this actually both for good news and bad news. So the companies, like the people you are in this webinar, can really realize what could happen and how you can really take full advantage of the system in China to protect your own mark or prevent yourself from the potential litigation risk. I will just go through quickly about the basic facts, and then I'll talk a little bit about what are the typical remedies in the Chinese trademark cases, and then highlight what does this mean to the foreign companies who is doing operation in China. So, the facts are relatively straightforward. I guess most of you probably have, know this mark, the French wine company, okay, the Castell. I never had this wine myself, but according to the press, it's quite famous in China now. By the way, a lot of French wines companies are doing a huge business in China. For some reason, the Chinese customers are buying the French wine like crazy. And one of the things that the French company did in China, like many other foreign brands do in China, is they used the counterpart of the Chinese counterpart of the mark Castell in China, which in this case called Castell, which is basically a phonetic transliteration of Castell. From this slide, you can have a picture of this wine. Now you can see the couture. I don't know if it's couture or couture, and then the Castell as one of the mark, and the Chinese name, which they use the French Castell and also couture, the wine. Okay. Now, what happened is, it turns out a Chinese local company has registered this Chinese counterpart mark Castell in Chinese before the French company. And then the Chinese company find out the big French wine company is using this the Castell, the Chinese mark, on their wines, and they filed a lawsuit against the French company. Of course, before that, according to the press report, they gave a warning letter to the French company. Apparently, nothing happened. Okay, I think the French company probably ignored it, or maybe it's some negotiation, but nothing was settled. So this Chinese company brought the French company to the Chinese court. Apparently, it's the home court where the plaintiff is based. What's very interesting in this case is that the Chinese plaintiff applied for this special measure, what we call the property preservation against the French companies, the trademark. Okay, I'm going to explain to you a little bit more about what property preservation later. But what happened in the procedurally, the local court granted the application and issued the ruling to freeze the trademark. Okay, you're probably already wondering what do we mean by freezing a trademark. I'll talk to you. I'll explain that in the next slide. But anyway, the current status that the court of first instance just conducted the trial. Okay, and actually the last couple of weeks the decision is pending. Okay, so what's so special? What's really so special about this case? In this case, the French company does not have establishment in China. They basically just have a wholesaler, to ship their wines to China and doing all the business, and they collect the money. But they don't have, apparently, they don't have subsidiaries. They don't have their staff in China, and so even if the Chinese plaintiff, won the case, it's very hard for them to enforce this decision against the French. But the property preservation could shift the game. Then, what is property preservation? Property preservation it's a court order to really freeze the defendant's bank account, okay, or the court order have the effectiveness to prohibit any transfer the titles of a property. Normally, it's a real estate, okay. In our practice, we always do that. Basically, because when we're concerned about the defendants that will run away or they will transfer the title of the property or take the cash out of the bank account, we actually will find a way to do that. Okay, we try to have typical tactics for the litigants in China. To get this order, we need to explain to the court, hey, there's certain likelihoods, the defendant is going to disappear, or the asset is going to disappear, or it's going to be difficult to enforce judgment against the other side. Normally, we're going to ask to put a bond. But what's very interesting is that very few people ever use this measure against this intangible assets, like a trademark or like patents. I think the rationale is that we focus on actually, we represent a lot of foreign companies in China, and because the other side normally don't have very impressive trademark or good patent portfolio, so those things are not really worth anything. If they do have some kind of trademark, they were more looking at cash or something for real, or even their cars or the property. But in this case, it's shifted because the other side is the French company, is a foreign company who don't really have too much on the in China. So the local company apparently have really strategized and figure out, hey, if I can find a way to freeze this trademark, and so the French company will not be able to transfer the title away to others, or the French company will be afraid of the trademark will be auctioned by the Chinese court, and then maybe the very good chance for the French company agree to settle with the plaintiff in some way. Okay, so that's why the local company really took this very aggressive measure to apply for the preservation against the trademark. To do this, they really paid a big price. In fact, what I learned is that they paid a big bond. In China, to get the property preservation, you have to put a bond with the court, deposit the bond with the court in case something went wrong. Okay, you cause some damages to the defendant, and then the bond will be used to compensate the defendant. Normally, the bond is paid in the form of cash. But for lots of local Chinese companies, because they have lots of real property in China and locally, and they actually can mortgage their property, get a certificate from the bank, and give that certificate away to the court, which will save a lot on the cash. So that's happened in this case. Reportedly, they put the mortgage their real property for 40 million RMB, which is about $6 million US. Now, the consequence of the property preservation, like I said earlier, is that, if the defendant loses or fails to pay the damages, then the court can auction off the property or sell off the assets and use the money to pay the plaintiff for the damage. But for the trademarks, theoretically speaking, court can do the same thing. Okay, they can do the same thing. What really happened is that the court issue an order, and the order will be sent to the Chinese trademark office. And the trademark office, has a special department for handling the transfer of the ownership of the trademark. Okay, when they receive this kind of order, they will put a notice to this particular trademark, which means that the trademark owner will not be able to retransfer the trademark away. Okay, they have to wait until the property order is removed. Of course, practically speaking, the trademark owner can still use this mark. It does not really affect the way the trademark owner uses the mark. But the freezing of this trademark really functions as a potential threat against the defendant. Now, what does this mean to the foreign companies? The bad news, obviously, that the foreign companies, the trademark portfolio, or if someone do that to the patent portfolio, this kind of the IP portfolios may be the target of the lawsuit that are filed against foreign companies in China. This could be a really negative news to those relatively small companies who have not really established much in China, but are doing a lot of business somehow with the, with some others in China, and almost everybody these days have some kind of a trademark rights or even patents in China. But when you're involved in a lawsuit or you name a defendant, your IP assets potentially could be used as a way to be enforced against in case you lose the case. So that's really the bad news. That's really the bad news. Of course, the story we picked up is not something that we have seen a lot. Okay, the Wenzhou court, where this property preservation order against a trademark was issued, is a little special. In fact, the Wenzhou court made a very controversial decision about, I think, 2 years ago. They issued probably so far the largest ever the damage award against, again, another French company, Schneider, I think electric company, for a patent case. They gave an award up to $50 million to a local plaintiff. Okay, and that's why this is really sort of aggressive. The Chinese court made this move, but what the problem is, or the concern would be by lots of commentators, that there's really nothing to prevent other courts from not doing the same thing, because the other court, the Chinese court, can really doing the similar practice and using the property preservation against the intangible assets like trademarks or patents. Okay, so that's really could be a new trend in the future, the Chinese litigation. But the good news is, even though I don't know how good this, how big the good news could be for the brand owner, is that when you are the brand owner, when you're trying to enforce your trademarks in China, you may really consider doing the similar things against the other side. Could be the Chinese company or even your potential international competitors. If you want to sue international competitors in China, you could think about, hey, if you think the trademark or the patent portfolio are worth something, and you should ask the court to freeze the other side's the intangible asset and use that as a potential leverage in the litigation. So that's the practical implication that we picked up from this case. So that's what I want to say about this Castle case. And again, I just really want to use this as an example of that one kind of remedies that you could consider or you really should take into account when you're doing the business in China. Okay, Janice?
Yeah, thank you, Hejing. Wow. I'm sure there's a lot of brand owners out there who are listening, and they may have some questions for Hejing on this or other trademark issues. Hejing has been practicing in China for about 9 years. Is that correct?
Yes.
And I'm sure that you have quite a few questions. So you can use the Q&A box to write in your question, or you can, is it *0, operator?
It's *1 to ask a question on the phone lines.
Can I begin, Hejing? As you know, the State Council recently, last week in fact, published another draft of the Trademark Law. Anything interesting that you've seen in this draft that you'd like to comment on while we have a few moments?
Yes. Just for the benefit of the people who have not really followed, the Chinese Trademark Law amendments recently, this Trademark Law amendment has been going on for at least 2 years now. Okay. Initially, the Chinese Trademark Office was quite ambitious. They made a lot of big amendments, even want to throw away the opposition. They're throwing lots of things, and it generates a lot of hopes and also controversies. But a lot of things were really pushed back eventually on the government side because we heard that some senior government people, they want to, minimize the controversies, only change the things that are really, unnecessary to change, or only change the things that are a lot of consensus to change. That's why from the second version on, the changes are quite, moderate, I would say. Now, last year, the amendments were sent to the State Council, which is the very, the key decision maker before the things sent to the National People's Congress for ratification. So after a year, the work of planning or the feedback taking, and then the State Council, the Legislative Affairs Office, issued the second version. And this version, to be frank, has, again, does not really have too much exciting items there. But there are a few things that I think I want to highlight right now. The first thing, which is a lot of Chinese press pick it up, and somehow they think it's, has some, really attract some attention, which is in the subject matter for trademark. Now, China now proposed in this amendment that they're going to allow the registration of sound, in the future. So I personally have never registered the sound of trademark in other jurisdictions myself, but it looks like I think the Chinese Trademark Office wants to be sort of consistent with the international practice, so they are really open and follow. Okay, so that's one of the things. The second thing, this what we call bad faith trademark filing. I think for the people on this call, probably a lot of you know that, or you may experience the what we call the trademark squatters in China, especially for some of the marks who are very popular outside China, like the U.S., the home market, or the Europe. But for some reason, they did not really come into China until lately. But it turns out when they come to the China market, they were surprised to find out the mark was already registered by someone else, in bad faith. Now, the current Chinese trademark law are not really properly equipped to deal with this kind of trademark squatters. To deal with this kind of thing, you have to prove you have some kind of reputation or relatively well known in China, which is really not easy. Actually, it's not easy for the sort of newcomer to prove that they are relatively well known in China before the bad faith trademark applicants, applied for the mark. So that caused a lot of controversies and problems. It has been heavily, discussed between the U.S. government and also Chinese government. Now, finally, in this trademark amendments, we saw there's some optional language that had been proposed to make the change of the of the law to make it relatively easier for the trademark applicant to deal with these problems. So that's one of the bad faith one. The other one was a little bit interesting. It's about the opposition, but we don't really think it's necessarily a good news for the foreign companies. Now, on the current practice, anybody can file an opposition, okay? Once the mark is preliminarily approved, normally there's a 3-month window time for people to oppose. Now, the trademark law, the new amendments now propose only those people who have this prior rights. Okay, let's say you have the copyright, the logo, or you have your trade name, or you are an interested party, or your party have a material interest, then you can oppose the trademark. This sounds nice because it was intended to prevent the abusive use of the opposition procedure, which can easily cause a delay of the registration for 3 or 4 years or even longer. But the problem is, in our practice, sometimes our client is not really willing to use their own name to oppose the bad faith trademark at the very beginning, because the stake is, if you really turns out some reason, if you lose the case, then you expose your identity, then the other side may really trying to blackmail you or get a lot of money from the brand owners. So that's why a lot of times the brand owner trying to keep anonymous or use a third party's name to do the opposition. But now with this new proposal, that will take away this kind of opportunity from the legitimate brand owner. So that's another thing we picked up. On the trademark enforcement side, which is one of the things that most of the trademark and the brand owner are really interested in, always focused on, it was disappointment that nothing really big was put in this the second version of trademark law amendments. They increased the statutory damages from 500,000 RMB to 1 million RMB, which is less than $200,000 US.
But there's no punitive damages for recidivist infringers, unfortunately.
There's no punitive damages. They did say for the administrative cases, and the administrative authority should increase the penalty, the fine against a repeated offender, and that's about it. Okay, and add a criminal liability in this law just to really demonstrate, to say, hey, there's a criminal liability, but nothing significant or reform was addressed to deal with the threshold of the criminal liability or clarify the threshold of the criminal liability. So it was just really no pleasant surprise in respect to the trademark enforcement.
Okay. Well, thank you, He-Jing. Operator, do we have any people who are ready for questions?
We currently have no questions. Again, if you have a question, you may press *1.
Okay. I actually, there's been a question that's been written in. I'll read it to the people who are listening on the audio recording. A listener asked, what would the French company have to have done to protect themselves before it came too late and their IP was used as an asset? What was their company structure? Did they have a rep office? Did they have any local kind of representation?
In fact, there's let me just reread this again. Well, it's not really about the company structure. The point I talk about, the fact that the French company has no establishment, that's really to highlight the scenario where even if you don't have any physical assets in China, your IP assets can still be exposed to litigation risk. Okay, and if there's any, right now, I don't think there's really a very effective way to prevent from this kind of risk, because for property perturbation, it is an ex parte proceeding. It is an ex parte proceeding. So for the defendant, you are not really involved in the decision. And of course, when you were notified about the freezing order, you could ask for reconsideration by the court. you could ask for the reconsideration of the court. But normally, once the big bond was posted by the plaintiff, very likely the court will not be willing to remove the order unless you can have some very good non-infringement arguments or have some very clear evidence to say, hey, the plaintiff is completely groundless. The Chinese court is very interesting, by the way. They really follow the money. I mean, if they really see the big bonds paid by the plaintiff, they think for your defendant, okay, this order does not reflect the way you use your trademark. Okay, let's just keep this order as it is, and let's see how it goes after the trial.
Hajing, someone asked a second question on what grounds can someone move to freeze a trademark? Do they need to provide proof of use before filing to freeze the IP right?
No need, actually. In China, in the trademark proceeding, to file the case, you don't really need to prove you have used it, even though most of the trademark plaintiff has used a trademark in one way or the other, okay? The basic grounds to move to freeze the trademark is to say, hey, there's a very strong likelihood of the infringement, and plus I have the bonds ready, and in this case they can say, hey, the foreign company, they're not relocated in China. If if the court does not do something, I may be vulnerable to the possibility that I cannot enforce this judgment against the foreign company. That's basically the grounds. The likelihood of the infringement and the difficulty to enforce.
Okay. There are two other questions that I'm going to combine them. One listener asked, what were the goods and services covered by the mark? And someone else asked if the mark was the word castle, C-A-S-T-L-E, or if it was the Chinese characters for the transliterating the word castle.
Right. I think the cover service is something related to the liquor or the wine. Okay. I don't remember exactly the exact wording of the cover, the goods, but it's definitely in the category of the wine or the liquor. Okay. It's at least a similar goods, and it's covered. The Chinese company's mark is the Chinese characters, which is the transliteration of castle, which again that's the same. The Chinese characters looks like are being used by the French company at least on their packaging.
Okay, so we're talking Class 33 goods and Chinese characters.
Right.
Operator, are there any people who have dialed in?
Yes, thank you. Our first question is from Andrew Wilson. Your line is open.
Actually, I had written a question. I apologize. It was already answered.
We'll move on to the next question. Richard Reynes, your line is open.
Thank you. I wasn't quite sure of the answer that was given to the question. Does the freezing order freeze the word castle in English, or does it only freeze the transliteration?
Okay. The transliteration was registered by the Chinese party, okay? And the court order was used to freeze the mark, the castle, in the English name, okay, or we say the Latin terms, because that castle trademark was already registered by the French company. That French company's trademark is the asset. That's why the plaintiffs say, hey, that's the asset owned by the French company, the defendant in China. So, the court, I'm requesting you to ask the Chinese Trademark Office to put a freezing, order. To agree not to assign this mark away to any third parties.
Was there a measure of damages based upon the sale by Castle of its allegedly infringing products?
Yes, that's in China. There are a couple of ways to calculate the damages. One way is that the loss of profits of the plaintiff. The other way is that the profits earned by the other side, by the defendant. Okay. Normally, it's not easy to find out exactly the amount of the profits, or it's very difficult to prove the actual sort of loss of the plaintiff because of the causational issues. China does not have this, the U.S. type of discovery, so it's not easy to do that. But for the foreign companies, they are normally more vulnerable because the foreign companies, normally they operate in much more regulated way. They have a much better accounting records, sales records. They have a good bookkeeping, and the plaintiff, can even ask the court to do what we call the evidence perturbation, to do some kind of a court directed evidence discovery to locate and keep the defendants, the account records or sales records. They can use that, and the plaintiff can use that against the defendant. In this case, in fact, the company, the plaintiff, is requesting for 200 million RMB as damages, which is about, I think it's about 20 million US, or maybe less than that. I think it's 18 million US dollars. The reason they ask for such a huge amount of damages is apparently based on their confidence that they are gonna able to grab a lot of sales records of the castles, maybe the sales agents or the distributors in China.
Is there any right of review of this decision?
You mean the freezing order, right?
Yes.
Right. You can ask for reconsideration, but not appeal. You cannot appeal this decision to the court of second instance. You can only ask the same court for the reconsideration, but normally it will not be granted. Normally the same court will not change anything unless there's something really, really terribly bad.
Somebody asked if the defendant can participate in the court auction. If the mark is auctioned off, would it be able to buy it?
I think so. But normally, for this case, let's say in a worst case scenario, if Castle really lost the case, and with its trademark frozen, I think that, if Castle cannot really overturn the case by appeal, they will probably just pay the cash, pay the damages, instead of having the trademark auctioned off. Of course, if they don't want to pay the cash and they want to buy it, and I'm sure they could participate in the auction.
Okay. Hajin, can we go back to the both the English and the Chinese character marks? Could you talk about that a little bit? Because somebody asked a question. She said that her company had registered a trademark both in English letters and then in Chinese characters, and she wanted to know what kind of protection that afforded her.
Well, the protection really gives to you that you have the right to use the characters, the Chinese characters mark, and also the English characters in the goods that was covered by the trademark. Okay, you have right to use that, when you register a mark in China. And on the infringement side, you can prevent anybody else from using a mark which is identical or similar to your mark, either Chinese mark or English mark, in the same kind of goods, in the identical type of goods or similar type of goods or services. Okay, so that's the kind of a protection that was offered by the Chinese trademark law. Of course, the caveat is, sometimes it gets a little bit confusing. Well, it's two things, right? Whether what kind of mark was essentially counted the similar mark, or what kind of goods is regarded, as similar goods. Okay, the Chinese courts normally look at several factors, like they actually, China uses NIS, International Classification Table, basically a chart, putting things into different classes, subclasses. If it's in the same subclasses, yes, that's similar. For some goods are in different subclasses, that can also be similar. But in some cases, they can also look at the normal type of users, the distribution channel, the nature of goods or services, and then determine whether the the covered the goods and the services are similar to the infringer's goods and services, and use that to protect the brand owners.
We have another question on the phone lines from Ed Marquette. Your line is open, sir.
Thank you for a very good presentation. It sounds like this property preservation is more intended to freeze assets, period, than it is a real trademark remedy. So I wonder, two-part question, if I have appointed a distributor for products in China, and let's say there is a dispute over that distributorship, which may or may not have anything to do with the trademark, do I run a risk that the distributor, simply to gain leverage, would, in litigation over the distributorship, might file a property preservation to hang up my trademark, even though the dispute doesn't relate to the trademark? That's the first question. The second question is, in my distributorship agreement, can I put in a provision by which the distributor waives the right to seek such a remedy?
Wow, that's a very good question. The first one, the answer is definitely your understanding is correct. Okay, it's really the leverage. Okay, it's the remedies that are offered to the plaintiff. Okay, that's a general remedies available in the Chinese, the civil cases. They, especially this could be that normally will be used against someone who does not have physical asset in China. Okay, so the other side could just ask the court to freeze your trademark, when they're trying to, enforce the judgments in some other type of cases. Okay. The second one is very tricky. In fact, you basically ask the other side to abandon the right to not to sue you, but it's a right is somehow in connection with the Chinese lawsuit. You just have to really structure. You have to structure the contract in a right way, okay? Because this kind of rights related to civil litigation is regarded by the Chinese law as something significant, and they don't want the litigant to abandon that, let that go easily. You need to put in some language to make sure there's a sufficient consideration, or using the Chinese legal terms, it's a fair for the other side to abandon the right to freeze to abandon the right to apply for the property preservation to freeze your trademark. Okay.
Thank you.
But normally I wouldn't, this is a very touchy one, right? Because this kind of thing is not really well known in China. When you really bring this up, you really educate the other side.
Okay.
You have to put a very general language, in fact. Very good question.
And we have no further questions on the phone lines. Again, if anyone does have a question, you may press star 1.
Anybody who's listening on the audio recording may contact Mr. He at his email address. His email is jing.he@zypartners.com, and he said he would be happy to answer questions on this case and other trademark matters. There's a question that's been written in. Someone wanted to know if they can get an English language copy of the draft of Trademark Law that's been published by the State Council Legislative Affairs Office. I do not have an English translation. You can get a copy of the law in Chinese at the State Council's website, and they're requesting comments on the law. Comments are due on October 8th, I believe.
Yes.
And we do have a few more questions from the phone lines. Laura Lee, your line is open. Laura Lee, please check your mute feature or lift your handset. Your line is open.
Yes, can you hear me?
Yes.
Thank you very much. Good morning, everyone. My question is that why, in this case, that the local Chinese court has the jurisdiction?
In this case,
yes,
well,
because it's an international business, and how does the trade agreement, in particular, whether it's existing or not, between the French and the Chinese government, or between the International Trade Association as a member or not, that how come that the jurisdiction is within the Chinese local government and the court, but not French or not an international court, or the applicable laws are only subject to trademark only?
Got it. Okay. Well, I should probably talk a little bit more about the background. This is what we call the trademark infringement case. This is where some Chinese plaintiff find out the French company is using the plaintiff's trademark in China. Okay, it's a very typical, sort of, we call the trademark infringement case. In China, the court, in a local court, can have the jurisdiction over a trademark infringement case based on the sales of products. China is not a federal system. Okay, we don't have federal. We do not have federal court or the state court. We just have the one national court system. Basically, the plaintiff can sue a defendant anywhere in China where he can find the defendant's the product. So in this case, I'm pretty sure it's just because this window, in window the plaintiff find out that the castle mark and the castle wine was sold in the local store in Window City. Okay, then what normally happens is that they will go purchase the wine from the local distributor and get the invoice. They normally have the witness by the notary public, and then they bring that evidence to the local court. Okay, and this is also called the form shopping. Okay, that's very typical in China and also in a lot of other countries, that the plaintiff prefer to do a lawsuit in a court which is arguably or believed to be friendly to the plaintiff, and we think that's the case here.
Thank you very much.
Our next question comes from Carol Nordstrom.
I just have a quick question. If we were not able to get onto your WebEx, is it possible to see that presentation, to receive that somehow?
Actually, we will post an audio recording, an FTP recording of this presentation on the stopfakes.gov website, Carol.
Right.
If you could send me an email, my name is janice.wingo@trade.gov, janice.wingo@trade.gov. I can send you to the website where we're going to have a recording of that, and it will be posted in about 3 or 4 days. You can see Mr. Ho's slides and listen to him again.
Thank you very much.
There's other presentations there as well, and they're all free.
Thank you. Our next question is from Richard Reynes.
Actually, it's from Michelle Cook.
Hi, Michelle.
Hi. I have a kind of a two-part question. The first is, if the defendant fails to pay the judgment and the auction or sale of the portfolio results in proceeds that exceed the value of the judgment, what happens to the excess? Does it go to the defendant, or is it a windfall to the plaintiff? And the second is, in this same instance, does the plaintiff have any right to seize the inventory of the defendant to help fulfill the judgment?
Okay, great. Thank you for the question. The excess of the auction will definitely go back to the defendant. Okay, the plaintiff will not get a windfall. Okay, because that's the value of the trademark, and the plaintiff can only get what was awarded by the court. Okay, and the second question is relates to seizure of the inventory. That really depends. Okay, if the inventory was also, we call was also seized by the court as part of the property preservation, then that inventory could be auctioned off or sold to pay for the awarded damages. Okay, but it has to be seized by the court and under the part of the property preservation.
Thank you.
We have no further questions on the phone lines at this time.
Well, if there are no further questions, I want to thank Hudging for speaking with us today. I'll let you know that Hudging has done 2 other presentations for us that can be found at the stopfakes.gov website. You can find them under the China IPR webinar series. He did one on domain names and also one on enterprise names. Both of them are only 30 minutes. And you can listen to them there, as well as in about 3 to 4 days we'll be posting an audio recording of this presentation. I'd also like to remind our listeners that on the 21st of September we will have another trademark practitioner from Beijing who will be we will be talking about famous trademarks. So it's 10 a.m. Washington, D.C. time, and a practitioner will be talking about famous trademarks on September 21st. Again, any questions for Hudging, you can give him an email. Any questions that the International Trade Administration can help with, you can contact me at janice.wingo@trade.gov, and we can provide some background information to you. Thanks again, Hudging.
Okay, thank you, Janice. Thank you, everybody, to come to this webinar.
Thank you. This does conclude today's conference call. We do thank you for your participation, and you may now disconnect your lines.